will is the document through which one person, known as the testator, identifies one's heirs and regulates certain family law relationships. It is written in accordance with certain formulae and may be freely revoked and superseded by a new will. Drafting a will of any type requires great care. Errors in the process and legal errors in wording may cause the will to be ruled invalid and put the testator's heirs in trouble. Greek civil law specifies 3 regular types of will: the holographic will, the public will, and the secret will. Holographic will. The holographic will is written, dated, and signed by the hand of the testator. It does not require formal proceedings, hence, it is inexpensive. Third parties neither learn its context nor that it has been drafted. However, holographic wills often contain terms that are invalid and unlawful. The testators of a holographic will often fail to seek legal counsel. That said, instead of putting things in order, their will has the opposite result. The testator may keep his will in a safe place or hand it into the care of a third party or a notary. Sometimes, the law requires that the authenticity of the will be determined by a graphologist. This is necessary, especially when the heir is not a close relative of the testator. Public will. A public will is drawn up by declaring the last will of the testator before a notary and 3 witnesses, or before 2 notaries and a witness. With this type of will, testators who cannot write or sign by hand can draw up their last provision. The will is kept in the notary's register, which eliminates any risk of loss or theft of the document by a third party. The risk of the will being invalidated due to vague wording is reduced. Moreover, a will of this type has the evidentiary power of a public document. However, the fact that the witness and the notary will know the testator's desires prevents many people from choosing this type of will. Finally, many testators do not choose the public will due to the fees charged by the notary and the consulting attorney. Secret will. The secret will is an intermediate type of will between the holographic and the public. The testator draws up a document that contains his last will and testament and files it with a notary. The testator should declare that this document contains his last will before the notary and 3 witnesses, or before 2 notaries and a witness. The document is kept in the notary's register, which prevents its loss or theft. Both secret and public wills have a disadvantage. They can be declared invalid by the court for purely formal reasons, or for the notary's omission of wording. However, if a secret will is cancelled due to the notary's error, then it is treated by law as a holographic will if certain conditions are met. A will, regardless of its type, must be published by a foreign governing authority, a Greek consulate, or a Greek court to take effect. Then the ownership of the deceased's assets can be transferred to one's heirs. Inheritance law is one specialty of our law firm. If you require valid legal advice for drafting your will, we will be glad to assist. We can also advise you on any inheritance law issues that may concern you. Thanks for watching.